Law Talk. Dane, DeKrey, Bruce Ringstrom Jr. in studio taking your criminal defense questions. Fellas, welcome back. Bruce, how you doing?
I'm doing well, Mr. Actions. How are you doing?
Doing well. Been looking forward to this conversation. I told you guys out there, Dane, welcome. Don't want to exclude you from the conversation.
We can do this without him.
Should we?
We should.
Okay. Your rebuttal, sir.
I'm just happy to be here.
We're happy to sort of have you here, too.
Yeah.
No, but I was telling you guys, since our last, our first show last month, people have been noticing because I get legal questions for you all the time, and we'll make sure to get some of those answered throughout today. Well, and quite frankly, just going forward, because you guys are going to be here every first Wednesday of the month, and it's a great conversation because people got questions, or they know a guy that did something that has a question. Somebody does have a question for a friend in here that I'll get to a little bit later on. But I do want to start with the news before we get to the questions from listeners, because there has been a lot of legal questions on the North Dakota side. Now, I know your offices are in Minnesota. We've explained, what you guys take on as far as clients, all of that. And if not, tell the website for them now before I forget to get that out there for Ringstrom DeKrey.
It's ringstromdecrey.com, and we are licensed in Minnesota and North Dakota in federal court in both venues.
Very good. That clarified for me. The Wayne Stenjum, the former attorney general of North Dakota, and what happened on Monday was a big legal question. In fact, you can take a step back to Friday. You can take a step back to when decisions were made about public records. And what happened, for those of you that are just tuning in that may not be following this, that there was an assistant of the former attorney general that had the deputy attorney general. They worked together. They deleted all the emails after Wayne Stenjum had unfortunately and untimely passed away. Just announced he's retiring, and all of that. Foundations there, Capital Punishment Podcast. But now we know that those emails, those public records are in fact there. There are so many questions that it's tough to even figure out where to begin. But I think we should start off with those emails that were deleted, because there's been things thrown out there saying that this is a crime, this is a public record that was destroyed. It seems muddled in all of this. You guys are criminal defense attorneys. If you have this case, this situation, where do you take it? Were they deleted illegally? What's missing here in the public discussion?
Well, part of the answer is it's a phenomenally complicated question, because at the moment that the emails were ordered to be deleted, was there an investigation? Could there be a claim of what's called spoliation? And Dane can talk about that. I want to jump ahead just for a moment. We know now that because Mr. Stenjum's cell phone had these emails on them, that they've recovered them. That is probably a minuscule portion of the total emails. Mm-hmm. And I am frankly shocked that that all of the servers were able to be scrubbed. I mean, that is a scrupulous act. Somebody had to be very motivated to remove all the emails. To answer your question legally, I don't know at this moment, but boy, somebody was deeply concerned about removing every single vestige of those emails.
Well, and those individuals were, I think an argument could be made, did not have the authority to do so. Now, there's the gray area of that. Was the deputy attorney general at that time, in fact, the attorney general, because the attorney general had passed away? There's also some of the back and forth of what piece of century code are they adhering to, because their conflict of interest that brought this to a different state's attorney and weighing it, and him to determine there's no charges being brought. There's a lot of conversation to be had there, but Bruce brought up spoliation. Dana, what does that even mean for an average Joe like me?
Spoliation is just a fancy legal term for you deleted something in anticipation of litigation or during litigation, or something that you didn't want the other side to see. And the normal recourse is there is no recourse, because once they're deleted, how do you get them back? Mm-hmm. And so to solve that, there's a doctrine of spoliation where a court can say, because you did that during this time period, we are going to assume that whatever you deleted is bad. And if you go to trial, we're going to instruct the jury to assume that it's bad, because otherwise there's no punishment for it, which would incentivize always deleting if you ever get yourself in a jam. And so it came to prominence after the Enron case, because the day that the Enron case broke, there was a company-wide email that said, everybody should do a very good job this weekend of clearing out their inboxes. And they did, and we didn't know what to do with it then. And so through various judges, they said, we can't let this happen going forward.
So there's other examples of exactly this. And I think, and Bruce, I'm not sure if you had any opportunity to read the email, which is completely ironic, that an email was what was used to declare we got to delete his emails. And it was that we have to delete everything before a public record request was in. Does that live up to a standard of saying, hey, we don't want the, quote, other side to have access to this in the spoliation?
Well, whether the other side is the right metaphor, it's not clear. Okay. You know, I think I read that email, and the writer of that email also said, because Wayne keeps everything, right? You know, there's all kinds of residue in email, and so there may have been any number of reasons why. What's interesting is every email that is received is also sent. Every email that's also sent is received. So there is a copy of each of these emails somewhere else. Does that violate North Dakota's Data Privacy Act or Open Records request? Possibly, but at the moment, so right now we know there's these criminal investigations going on. At the moment, maybe the actors knew about it, but it certainly wasn't a matter of public record, and there's certainly plausible deniability. So at what level of violation did this happen? And frankly, what's the recourse? What if one person gets in trouble, but with all of these data that have been deleted, various other investigations may be able to go nowhere?
Speaking of data, you know, we're focused on emails because that was the crux of this. And now I think because of what we know now, it's not just emails that have been put into the public world and put into investigations. There is a former state senator, Ray Holmberg, up in Grand Forks, who is federally charged in very heinous things, just terrible, disgusting things. What we found out on Monday from the current Attorney General, Andrew Wrigley, is the cell phone that had the emails also had text messages. The call logs have been retrieved as well. And the way I understand it, Dane, I'll kick this to you, is that was because there was a federal warrant to access the former Attorney General's phone. What's that mean? How'd that come to be?
So it's a search warrant. And in order to get a search warrant, the police, law enforcement, have to write up a request to a judge. The fancy word is an affidavit. And you basically tell the judge, here is what we're investigating, and here is why we think there will be things related to our investigation that are criminal on this cell phone. And if they can convince the judge that there is probable cause, that doesn't mean it will necessarily be on there, but there's a good chance, then a judge will sign a warrant and say, you can grab that phone and you can search it, even if the people don't want you to, even if they wish you wouldn't. It basically gives you a blank check to grab that phone and look for evidence related to the crime that they're investigating, which likely is related to Ray Holmberg.
Now, Tyler, I will tell you, this may surprise you, but the more power and resources that somebody under investigation has, the more seriously these search warrants are taken. An average search warrant in federal court may have, you know, it depends, somewhere between 5 and 25 pages of an affidavit, the sworn statement to convince the judge to get this information. It wouldn't surprise me if the affidavit is 100 pages or longer here.
Really?
Oh, I go ahead, Dane.
Well, and I would imagine that everybody is looking at it maybe a little closer than they normally would on a normal search warrant. And that's not to say every warrant's not important. Everyone's constitutional rights should be protected. You should only be searched and seized if there's probable cause. But this whole case has taken on a different dynamic with using a different grand jury and being very cross your T's and dot your I's. So I would imagine that this is one of the most reviewed and scrutinized search warrants that we've seen in recent history.
When we come back, Bruce, I'm going to let you ponder this question because you talk about how long this affidavit is because of the importance of the individual that you're accessing this phone. That individual was deemed as a witness and somebody who did not recuse themselves based as a the chief law enforcement officer of the state. I want to get your reaction to that when we come back. Right now in studio, Bruce Ringstrom Jr., Dane DeKrey. Bruce Ringstrom Jr., Dane DeKrey, Ringstrom DeKrey Law. There, I finally got that right. It just took me 3 times. You got questions? We will get to those, I assure you, when we come back here on KFGO. Ringstrom DeKrey, that's where you want to go. RingstromDeKrey.com, the duo in studio. We're talking about the developments in the Wayne Stenjum devices. And where we left off was about recusals and whether or not, as somebody who was the chief law enforcement officer in Wayne Stenjum for the great state of North Dakota, who knew that his personal friend for a very long time was under investigation, should he have recused himself? And then we find out on Monday that he was designated as a witness in the Ray Holmberg trial. Bruce, I threw that question your way. There's some grayness to this when it comes to what does a witness what does that mean in this situation? That he was designated as a witness. Does that mean he knew? Does it mean that, hey, we just want to ask questions? Is it that wide open in this situation?
Sure. In a pre-indictment situation or in a state court, if somebody's not been charged, witness means something different. So if I'm representing somebody charged with a crime and I get a witness list, that means something that I have as a defense attorney, have certain responsibilities to disclose information and so on. If they're a witness in a pre-indictment situation, it's different. But I want to answer your question. I think there's 3 possible reasons why Mr. Stenjum did not recuse himself. And I will not opine as to which one because I do not know. The first one is that he wasn't fully cognizant of the fact, whether he wasn't paying close attention to it, whether he was in mental decline. There could be something like that. The second is that he knew very well, but he was a model of propriety and had been a clean actor his entire career and just decided, look, I know all these people. This is a small state. I'm not going to recuse because I will do the right thing as the chief law enforcement officer of the state of North Dakota. And the third possibility is that he was a bad actor, that he knew something he didn't want to recuse at that moment because he wanted to shape the investigation. Those are the 3 possibilities.
Well, and I ask this because there's a federal investigation into a former state senator, somebody whom I served with, somebody who the current U.S. attorney and Max Schneider served with, and Dane, I'll kick this to you. Immediately when this came to light, Max Schneider recused himself based what I assume is just on the fact that he served with him and they were both residents of Grand Forks. So it seems in that aspect, Max Schneider's like, yes, I can't have anything. Even the appearance is bad. Wayne Stenjum took the opposite approach, but I'm curious just your reaction to the 2 different approaches here.
Well, I think that we want to hold our chief law enforcement officers to a high standard. And so, accepting what Bruce talks about, which I do think is the correct way of framing it, there also is a second level to this, which is you should probably err on the side of extreme caution. And Max Schneider did that. I would venture a guess that Mac knew Ray Holmberg much less than Wayne Stenjum did. And despite that, because the last thing you want to do is to taint an investigation of this magnitude by something that seems so unnecessary to do. Mac probably could have kept on the case. I would imagine that he's got the scruples that Bruce talks about. But out of an abundance of caution, he didn't do that. And so when Mr. Stenjum does that, I can't say there's ill motives imputed to it, but it just would seem like an unnecessary thing to do when you could have easily taken the same path that you saw another chief law enforcement officer do.
Well, and right now we're left to just speculate. Bruce, you brought up there's 3 scenarios there, and we can't say which one it is because we don't know. That you can't glimpse into an individual's mind, feelings, certainly now that they are gone to us, but there might be something in the cell phone data. And one thing I heard from Drew Wrigley, the current Attorney General, is we've got these communications. If you've been a part of this investigation, if you've been questioned in this, it's time to probably reach back out and correct some statements. What do you read into that type of comment as?
I read into that there's a handful of very important people in North Dakota who are terrified at this moment because they may have allegedly given false statements to a federal agent. And that is one of the main ways. If you can't convict someone of a substantive federal charge, like guilty of fraud or whatever the case may be, you convict them of lying to the FBI. And so will they be able to amend their statements? I don't know. But I think the content of that phone is going to constitute a bombshell.
Dane, DeKrey, Bruce Ringstrom Jr., they're here for you. I got to get you caught up with KFGO News. I see your comments, your questions coming in to 35270. We'll get your legal advice when we come back. Law Talk, right here on Afternoons Live. Law Talk. It is the first Wednesday of the month. That means Bruce Ringstrom Jr., Dane DeKrey in the studio. We're going to wrap up a few of these messages that came in about the news and their expertise in it. I'll throw this out. Either one of you want to take a swing at it, go ahead. Tyler, what impact can the info of these emails have on, for example, the Susan Bala case or the Andrew Sadek case? Is there any new information that can reopen these cases? Thanks.
So the Susan Bala case is the 2005 gambling case. I think that was actually reversed.
Yep.
So I don't know. I mean, depending on how bound up this is, I think it's unlikely to change the outcome there. The Sadek case, on the other hand, it's possible. However, there would have to be something in those emails that showed that there was some malfeasance on the part of the AG or something that has not come out in discovery about that particular incident that was covered up. And it's possible, and I'm not saying there is nothing covered up in the Sadek case, but what is the statistical likelihood that it would be on Wayne Stenjum's phone? I think it's low.
Okay. Another one, thanking you guys for the insightful decision to utilize your expertise to go down the path of this. It's been enlightening and informative. Lastly, here they go, understanding the implications of the search warrant and what may have been discovered on Wayne Stenjum's phone has given me pause. But kudos to you guys coming in from listeners. Let's get to the questions. You got somebody that you know that has some legal troubles? They've got all the answers for you. Send them in to 35270. Tyler, question for the lawyers. Do you help with expunging records?
The answer is yes. We do expungements in North Dakota and in Minnesota. North Dakota typically is much more difficult to get a record expunged. There's an actual expungement. There is a mechanism by which you can seal electronic records. So if somebody's looking your stuff up online, it's harder to find. And there's one other mechanism. There's also a gubernatorial pardon that you can possibly look at. But the enumerated expungement crimes is very small. It's larger in Minnesota. The thing that people don't like hearing when I tell them is come back in a couple of years, because the longer it is between the end of supervision and you do good things and then you get your it's more likely to get it after a meaningful period of time.
So do I understand correctly that there's a longer list of things in Minnesota that would be taken off your record? Any reason why that one state says, yep, we can expunge your records for all these things, and the other is like, nope, just this little group here?
Well, candidly, North Dakota has a more punitive view of criminal justice. I mean, they just think that there's a smaller group of crimes that deserve to be expunged. I think marijuana possession is one of a very few in North Dakota, for example.
And correct me if I'm wrong, I think that was a recent change in the legislature as well when it comes to criminal justice reform.
And Minnesota is even moving this session to do more and broaden it more. I know that the current Attorney General is expanding the pardon board and the expungement board. They just seem more active and more interested in trying to give more people second chances.
I imagine there's going to be people that are thinking right now, well, yeah, it's because they're weak on crime, right? That they're letting everybody off. We're not filling up jails. In fact, there was a conversation I was having with somebody it was at the end of last week. Doesn't matter. It was recently of law enforcement saying that they don't have anybody in jail, that they're letting people off, with some of these crimes, and they're just back out on the street slinging drugs, whatever it might be. You guys are criminal defense attorneys. I'm curious your reaction to a law enforcement officer seemingly saying that in Minnesota in particular, that we don't put people behind bars like we should.
Well, crime peaked in the United States in 1993. I think we've talked about that before. It's gone down ever since. There was a little bit of a spike during COVID, but it's continually gone down over time. As I look at the total crime index in North Dakota and Minnesota, they're almost identical. They're very, very similar. So no, I would just that police officer is making an anecdotal judgment, and that's fine. But go talk to the corrections officers that work in the Cass County Jail. It is bursting. We are putting lots of people in custody right now.
Dane, anything to add to that?
The only thing I talk about, and we talked about this when I used to be with the ACLU, is, I always push back on this idea of being hard on crime or soft on crime. Those words don't really mean anything. And I think what we should always be looking for is being smart on crime. And I know as a criminal defense lawyer, I take a different perspective when the criminal justice system, rears its head. But to just say those broad terms without thinking through, I would push back. I think Minnesota is trying to find the right balance of what smart on crime means for their citizens. I think North Dakota is doing more than it used to, but I just don't believe in that narrative. And I think that people should be skeptical when they hear that broad brush stroke.
Minnesota is much more engaged in rehabilitating offenders. If you compare Minnesota's recidivism rate to southern states that are much more punitive, the recidivism rate in Minnesota is far lower. We do a better job at helping offenders become law-abiding, tax-paying citizens.
Well, that's that transition from incarceration to getting back into a home, getting back into employment's not easy. Do you guys take any part in that on the legal side from Ringstrom DeKrey? Because I get, I'm out, but I'm not used to this outside world, and I'm dumbing it down. But what's your law firm involved in that aspect of out of prison, back to work, back home?
At this point, we were far less involved in that. Both Dane and I were public defenders at one point, and so we represented almost exclusively people that didn't have the resources to hire lawyers, and so we were involved in that more. Typically, when somebody gets released from prison, they get a parole officer, a supervision officer that is supposed to facilitate transitional housing and things like that. But no, we don't do that as directly. We do provide advice, and people call us all the time, and we do our best to give them the kind of guidance that they need.
Very good. Questions in. I'll get to those. Tyler, question for the attorney dudes. What are the 3 types of plea bargains?
Well, dude, I don't know that I would characterize plea bargains in 3 categories. In North Dakota, there can be plea agreements where it's locked in. The prosecutor and the defense attorney come to an agreement, and the judge can either accept it in its entirety or can reject it in its entirety. Those are actually pretty rare in North Dakota. They're more plea recommendations. That's the way most Minnesota plea agreements are. You're kind of locked in. I don't know about 3 different kinds, good, bad, and the ones that you get at Ringstrom DeKrey, which are awesome.
Brilliant. Put that in that next ad, boys.
Right.
Please do that. Questions in for you. RingstromDeKrey.com is where you can go check it out. Bruce Ringstrom Jr., Dane DeKrey, our guest. It's Law Talk here on Afternoons Live. Tyler, question for the lawyers. What's the law in North Dakota regarding trespassers who refuse to leave your property? Obviously, letting law enforcement handle it would be ideal, but can the trespassers be physically removed if they have been asked to leave? What about trespass vehicles on property? There's a lot of questions coming in that, but I can repeat. Whoever wants to take a swing at that.
Well, I know North Dakota and Minnesota are different in terms of the duties related to trespassers. Some of the principles that are involved are whether you have to retreat back into your home, whether you can stand your ground. I know that North Dakota has much more landowner or private person friendly laws in that regard. I don't know the exact specifics off the top of my head of what you have to do before. I see Bruce is feverishly typing, and so my guess is he's going to give a little update there. But from the broad strokes, in North Dakota, you are much more allowed to defend yourself, your property, than you are in Minnesota. But, Bruce?
Yeah, so in North Dakota, you are allowed to use, and boy, if anybody takes this as legal advice, I will disclaim that I ever said this, now that it's recorded for all eternity. You are allowed to use a certain amount of force to eject someone from your property if they've been formally trespassed. Unlike in Texas, which as recently as 2018, you could use lethal force to defend property. In Minnesota, you really can't. What I would say is that, you have to, number one, tell the person that they're trespassed. Number 2, you can sort of, stand in the way between you and the door. But really, it moves beyond a misdemeanor trespass and into a burglary or a home invasion pretty fast. And then you do actually have rights to use force to get someone to leave you alone.
Oh, very good. Fellas, we got a caller that wants to ask you a question as well. We're going to get to the phone lines. You can call into 237-5948. And I'm going to let Mark talk to Ringstrom DeKrey. Mark, thanks for calling in. What's your question?
Hi, good afternoon. I have a question about Marcy's Law and how that, that I don't think we knew what we were getting when we voted on that. But if I'm the victim of a crime and the case is plea bargained, am I entitled to have a say in that plea bargain under Marcy's laws? If I'm even in fact notified that there's going to be a plea bargain, whether it be a property crime or a crime of violence, what are my rights as a victim? And how do you, as a defense attorney, do you contact the victim, or is that purely up to the prosecution? Because, I mean, we all know victims have less rights than the suspects, but that's my personal opinion. Thank you. I'll hang up and listen.
All right, thanks, Mark.
It's a great question, Mark. Before Marcy's law, North Dakota, like most states, had a victims' rights statute. The state's attorney is supposed to contact the alleged victim. No one is an actual victim until someone has been adjudicated guilty. They're supposed to contact the alleged victim and inform them of possible resolutions and hearings and things like that. Marcy's law strengthens that. Marcy's law also takes away the right of the defense to depose or interview the alleged victim before trial. And that was something that existed in North Dakota for a very long time. So you do have a right to know the trajectory of the case if you're an alleged victim. And, we are defense attorneys, but as citizens who care about justice and due process, if you believe you are a victim, you should not wait for the state's attorney to reach out to you. You should be proactive.
35270. You got about 10 minutes left to get your questions answered from Ringstrom DeKrey Law. They're in studio. It's Law Talk right here on KFGO. Appreciate all the comments coming in about how informative this conversation is. And I guess we're all in luck because every first Wednesday of the month, we're going to bring these boys back on in Law Talk. Bruce Ringstrom Jr., Dane DeKrey. You can go to ringstromdekray.com to check them out if you need any legal advice or representation. Fellas, just talk a little bit more about the firm. This is only the second time we've had the show. Certainly we got new listeners every day here. But explain the firm, explain what you represent, all of that for us again here.
Sure. So my father, Bruce Ringstrom Sr., started Ringstrom Law about 45 years ago. He practices criminal defense at age 75. He is still doing excellent work. He still comes to the office almost every day. 2.5 years ago, Dane and I partnered. Dane has real expertise in federal criminal defense, and I'm much more focused as a gritty state defense attorney, trying cases in smaller courtrooms. We are 95% focused on criminal defense in state and federal court in both Minnesota and North Dakota. We also do 1983 work, which means we will sue the police for mistreatment of citizens or sue the government for things that they do, violation of people's rights. That is what we do, and we're not going to take any business work cases. We're not going to do any divorce work. We are only going to represent people charged with crimes or sue the government.
What's interesting, I'm sure you guys get this all the time, because I can have a doctor on that's a specialist on pick a body part. And then they'll get questions about every other body part. Well, they're not the expert in this. I imagine you guys get questions about leases. You get questions about, you mentioned, Bruce, divorces, all these other things that, yep, you're attorneys, but you're very focused on criminal defense.
You know,
right?
Tyler, we specialize even within the field. So Dane has a large federal case. He did a huge amount of legal research to isolate the suppression issue, to get the evidence thrown out. He helped me understand the law, and then I was the one who actually cross-examined the state troopers. So we work as a team because I've got a faculty that he doesn't. He has a faculty that I don't. We come together and we really kind of narrow in. And if you think about a complex surgery, you might have two surgeons around the operating table.
Hope that's instilling confidence for all you guys and gals out there that might need to make a phone call or go to a website, Dane.
Yeah, and what I will say, if you have a question and you don't know anywhere else to turn, we have people that we know who do that work. We are happy to refer that. I don't want to leave anyone out in the cold here. Part of this show is to really show people, if you have a legal issue, you have nowhere else to turn, you don't know what else to do, give us a call, send us an email. Even if we can't help you, we'll point you in the right direction too. So that's the last part, that we don't want anyone to feel like, well, if I don't have it, if I don't know, like, call us still. We're still going to help out.
Yeah, because I imagine, thankfully, I have not had to make a phone call like that. Of saying, hey, look, whatever the situation is. I imagine that's a scary phone call to make, and it probably shouldn't be, is what I want people to leave with by these conversations as well.
Yeah, and I will tell you, we have one of or the greatest office manager, receptionist, a woman named Roseanne, who is the nicest, best person you can talk to on the phone. I hope she's listening. She deserves a shout out. She takes the vast majority of our intake. She does an excellent job. There'll be no judgment. There'll be no feeling bad. We'll ask you the questions. We'll get you in. It's a really as good as the experience can be in a bad situation. We have a team that really makes it the best it can be.
And I'm glad Dane brought that up, because 3 or 4 times a day we are talking to prospective clients and helping them find the right lawyer if it's not a criminal defense matter.
We do have another call in, and I'm going to have to make this quick for you guys. Lance, I've got about a minute for your question for Ringstrom and DeKrey.
Sure, I think it's quick. You hear a lot of news about grand juries or grand jury indictments, but not in North Dakota. Is that just some states have that? And what is that? Or is it maybe just a federal thing?
Well, virtually all federal cases begin with a grand jury. Not all of them, but the vast majority. A much smaller percentage of state cases begin with a grand jury. Grand juries are typically used theoretically, if a prosecutor doesn't know if it's a crime or not, they call a grand jury to see if the grand jury will indict. But usually it's a political tool to sort of insulate the prosecutor.
And in some states, it's also only for very serious crimes that they do require a grand jury to charge. Federal, we assume everything is so serious, so it's done by a grand jury, but it's far less common in state.
So, for example, like first-degree murder, you can't be charged with first-degree murder without a grand jury in Minnesota.
Very good. Fellas, before I let you go, I see that 5 o'clock punch-out coming right around the corner. Lance, I appreciate the phone call. Give the website again, give the address, give a phone number that people listening saying, you know what, I got to make a phone call, or I know a guy that needs to make a phone call. Bruce?
If you know a guy that knows a guy that needs a criminal defense attorney, it's ringstromdecrey.com. Our phone number is 218-284-0484, 218-284-0484. And not that you need the address, but it is 814 Center Avenue, Suite 5 in Moorhead. We're on the north end of the Swing Barrel building, so come on over and see us.
And I think the other thing that's important is that if you call us, the biggest fear is, are you going to charge me? If I come in, are you going to make me pay you to talk to you? We do not do that at all. That is not our model. We want to help you, even if we end up not being the person to represent you. If you find a different lawyer for your criminal case, if we have to help you refer to it, part of our job is to provide a public service. That's why we started the radio show. We will meet with you for free to help you get in the right direction when you have a problem.
Dane, Bruce, it's been fun. Let's do this again next month, all right?
Yeah, I think we really should do it next month.
Good, very good. Ringstrom DeKrey Law. Folks, that means this is it for me today. I'm Tyler Axes, your host here on After He's Live. Until tomorrow, you take care of yourself. I'll check in right here on KFGO.